Member Hamilton, Member Enriquez, and Member Jackson. Let me welcome Governor Biles and his team from the Bank of Jamaica to our meeting, and welcome all those who are listening. Member Hilton has joined us online. And so at our last meeting, we had made certain requests. But I want to just say that our meeting date was originally, we wanted to have our meeting on the 11th. We all know what happened prior. We had burial. And so the convenient and members of the Bank of Jamaica had indicated to us that the date that was proposed for the 26th would not, was it the 23rd, 26th, 25th, would not have been convenient, and the 18th, today's date, is a more convenient date. And so we are here today to do the business of the government.
Chairman, just before you proceed, and on that matter, I must express that I think it most unfortunate because Member Jackson's motion is unfortunately not here today as we convene. And the circumstance under which he's not present, I think, is something that we should reflect on. And I believe that there was a responsibility on your part as chairman to ensure that not only was the date convenient to the Bank of Jamaica, important as that is, but that it was convenient to all the members, or certainly a majority of the members, for the proceedings to go forward. It is unfortunate that even as we convene today, Member Jackson, whose motion it is and who has a particular interest in the matter, that is on board a flight elsewhere. And I think it is to be noted and to be regretted that the necessary consultation, notwithstanding what the standing order says, having regard to the circumstances of the postponements and the resetting and postponement, I think that the responsibility devolved on you to have had some internal consultation with the committee members before setting this precise date, notwithstanding the convenience to the BOJ, which, as I indicate, is important, but it cannot be the only deciding factor, having regard to the history and the postponements that have been made in this matter. So I must put on record my concern, and I believe that it is regrettable that we're proceeding in a context where the member whose motion it is not able to be at this meeting, and not because he's not interested, obviously not, but because there's a conflict in the scheduling, and that conflict, I believe, might have been avoided.
Noted, Member Hilton, but I just want to say that I can recall it is Member Jackson at some meeting about 2 or 3 meetings ago who had stated when we were setting dates for meeting that meeting is not set around any individual member, and that the business of the government or the parliament must go on. Consultation was made as per the procedure of the House, where the dates was circulated and membership the members had indicated who are able to attend and who are not able to attend. And we are able to have a meeting today, right? I do understand circumstances that will cause a meeting to postpone. But Member Hilton, you would recall that it was Member Jackson who had indicated in the House of Representatives that we are shying away from having meetings, which was not it was not the fact. And the fact was expressed that the meeting was set for a particular date. So we do not wish to have this perception that we are shying away from meetings. We are not. In fact, the records would show that since I've taken the position of chairman, the amount of meetings that this committee has been held in such short time is a record already.
What is that number of meetings?
All right. So let us not. I will get that information and pass it on to you, Member Hilton. Let's not detain the meeting with regards to that. Okay.
I must say on the record.
The record, you will get the record.
No, I'm not requesting. I am stating my position on the record.
And I have stated my position on the record, Member Hilton. Can we...
No, please. No.
Go on.
No. I'm saying this is the second meeting of the committee that I have been privy to.
No, this is the third meeting, Member Hilton, since I'm chairman. This is the third meeting.
Chairman, the issue...
The clerk of the committee has just confirmed that it is indeed the third meeting.
I will grant that it's the third, but it cannot be a number of meetings. This is the third meeting, and Chairman, I will say, on the matter of consultation, I repeat, it is unfortunate that the consultation, because on the 11th, when the meeting was set for the 11th, another postponement occurred, perhaps necessarily, but the several postponements that have occurred since we initially set a time for the meeting must enough necessity be taken into account in terms of members' availability, and I think it's unfortunate again. And I must say that, and that cannot be excused by saying that you've had a number.
On a point of order, Member Hilton.
This is the third
On a point of order, Member Hilton.
What is the point of order?
There has never been more than one postponement. It's now several postponements, Member Hilton. One postponement.
The last
okay.
one was set on the 11th.
It's not several postponement. That is a point of order that I am raising. So I ask that you withdraw that comment.
In any event, my position stand is regrettable. Member Jackson is not here.
Your position is noted. Let us take the confirmation of the minutes quickly. The minutes having been circulated, I ask that there be a confirmation, and that is the meeting dated Wednesday, May 1st, 2024. Can I have a confirmation from Mr. Wilson, Member Wilson, seconded by you, Member Hilton?
I will have the seconded, sure.
Thank you, Member Hilton. We move now to the presentation from the Bank of Jamaica regarding their legal opinion on the banking fees and other issues. Over to you. And you could just introduce your team.
I have with me Senior Deputy Governor Wayne Robinson, Deputy Governor Jide Lewis, who is in charge of supervision, and General Counsel and Deputy Governor Celeste McCalla. So we are fully prepared to answer questions and to make the presentation on the question of dormant accounts, as well as the experience with automated banking machines. So I'm going to ask Celeste to open the button with the dormant accounts.
Good afternoon. So the bank provided its opinion on the matters of 1, does or should the lack of the use of a bank account by a customer prevent the application of fees or charges on the account? And 2, is the practice of applying fees and charges on such accounts illegal? Prior to answering that question, we did a little background and context for the benefit of the committee members. And we noted that while the terms bank account and savings account are not defined in the Banking Services Act, the terminology account and dormant account and product or service, those are actually outlined in the Code of Conduct, which is promulgated under the Banking Services Act. We recognized that in relation to dormant account, that those set of accounts can in fact be caught within the set of accounts known as unclaimed monies, or treated with as unclaimed monies under the Banking Services Act, because that is defined as an account by which no form of activity has occurred for 15 or more years. There is a mechanism by which a person can claim the funds in the account if, after we have treated with it as per the statutory methodology, the person comes forward, the account holder comes forward to claim the funds in the account. So we gave a little background and context so you know what it is that is covered in our Banking Services Act and where we might have touched on the subject of dormant accounts in our framework through our Code of Conduct. Essentially, because the dormant account is it's a service offered, it's a savings account, a regular savings account, and the label dormant really applies to whether or not there has been usage on the account. It's subject to the same arrangements that would apply to a savings account, including the application of fees and charges, because the banks would normally be required to ensure that, as is the case with other savings accounts, the account is not abused, that they are reporting correctly in relation to the account, they are applying the interest accordingly, and whatever charges need to be applied, those are being applied accordingly, and that whoever accesses the account is actually the account holder or has the authority to access the account to make sure the account remains intact. And so while the subject of applying fees in relation to dormant accounts or accounts that are not in use for a period of time, it's not treated within the Banking Services Act. What the Banking Services Act covers through its Code of Conduct are disclosures that should be made to customers, disclosures of terms and conditions of products and services, disclosures of complaints, mechanisms, disclosures of what is in the account that is owed to the customer in the form of that, the funds held in the account, charges, etc. On the matter of the practice of applying fees and charges on such accounts being illegal, again, because it's a regular savings account and fees and charges are part of the methodology that banks use in their daily operations to manage those accounts. And the BSA as well does not prohibit the application of fees in relation to such accounts. Our conclusion is that it's not illegal for such charges to be applied against the account. There could be a discussion on terms of reasonableness when it looks at what is applied in relation to the such accounts. We went a little further to see what some of our counterparts elsewhere we're doing in the region, and we saw where there is, in fact, application of fees to dormant accounts. One circumstance, one jurisdiction actually put a limit on how high you can go with the charges, and I believe that was Barbados. That information, Chair, is set out at Appendix 3 to our submission for your benefit, sir. And in relation to the practices locally on fees and charges, I will yield to allow my colleague, Deputy Governor, Dr. Lewis, to just give you an overview of that, sir.
Thank you very much. So, as was stated in the previous committee meeting, there is no DTI currently that levies a charge for the management of dormant accounts. That practice would have ended across the sector over 3 years ago. And the practice now is, the reason cited, and some of these have been made publicly available, meaning news stories have been written on it, cited by licensees is that previously when they had manual processes, they had to employ labor to administer these accounts which had gone dormant to ensure that the matters to which General Counsel Celeste spoke of, making sure that nobody has access to the account, making sure that all the KYC documentation is up to date, and other requirements that they would have. The industry, there were 2 banks in particular, had deployed technological solutions to allow them to effect those administrative processes, and hence they felt that there was no more need to have an administrative fee for that. They absorbed that and used technology to allow them to meet their obligations. So that was back at least 2.5 years ago. What has occurred since then is that the bank would have implemented some thematic studies of the entire banking system about a year ago. And one of the matters that we would have evaluated was the extent to which banks had electronic mechanisms to alert them as to when dormant accounts were being accessed by members of staff. This was flagged as one of the typologies for fraud, specifically internal fraud, for which we required banks to demonstrate that they had what is known as transaction monitoring systems. They had transaction monitoring systems that allowed them to determine when a dormant account was being accessed by a member of staff. And when we did that review, we found that a large percentage of banks had those systems in place, and the ones that didn't were given a period of 8 months to implement that technology so that they could be notified. When I said the nominating officer, who is the person at each financial institution who's responsible for managing AML and CFT-related matters, that person would have a mechanism to alert them. And so I can say now very confident that all banks have that system deployed, and therefore there's a technological solution that has been used to allow them to meet the administrative obligations under our guidance notes and ultimately under the Proceeds of Crime Act. So that is the status of things. So I will summarize. There are no banks that are charging dormant account fees. They would have done so in the past. At least 2 DTIs have indicated that have done so in the past because of the administrative manual nature of providing proper compliance for those kinds of accounts. It is no longer the practice to use manual processes, but rather to use technology, and that technology is being applied across the banking sector and has been verified by the supervisor. Thank you.
All right, Chairman.
Yes, Member Hilton.
Thank you.
Be-
So with that clarity as to what the position is to date, is it fair then to say that where the solution, as in this instance, has been a technical one, that really, in order to safeguard those accounts, that the Parliament and the government and the Parliament ought properly then to put in place a policy or a directive, a clear legislative or regulatory um, um, or some kind of resolution to ensure that this is now outlawed. Not just that the banks no longer need to do that, because things can change as the conclusion, as the opinion concluded. They have the right under the existing legal arrangement to so do. But that because the grounds, the basis on which they were doing it was simply because there was some administrative cost attaching to it. Therefore, and that has been resolved through technical means, they no longer engage in that practice. But I believe the Parliament and the government have a responsibility to ensure that that is not reverted to. Because so far as I'm concerned, and I'm very pleased to hear that the internal situation in the banks is now such that whenever a member of staff interferes with or accesses an account, there's a mechanism to trigger a warning. That, I should say, Mr. Chairman, is a welcome development, because my understanding, as explained to me by a previous president of the Bankers Association, was that the chief risk that those funds faced were risk from the employees themselves internally. And so, and therefore my concern was, and really up until now, my concern remains that if members of staff were the ones interfering or accessing these accounts, then the responsibility must devolve on the banks to address this situation. And the Bank of Jamaica, as was just indicated, has provisions for them to report where their staff have so acted. And those risks are properly to fall on the banks themselves and not on the depositors. Because, as was indicated, and we're coming to shortly, there is a mechanism that although for 15 years the account may not be active, the funds, until it escheats to the government, belong to the depositor, who can, either arising from a coma or some long foreign trip, could come back and claim their funds. And since it is not an administrative burden any longer, and the risk of cheating from the fund or accessing these funds or defrauding the fund should, from the very beginning, should have fallen on the banks themselves and not on the depositor. So I'm seeking the confirmation then from the bank, from the BOG. Is it not then appropriate in the circumstances, in all the circumstances, that and wise that the government and the Parliament move to put in place concrete laws and regulation to prevent this from recurring? As in the case of Barbados, a cap has been made, but the cap is no longer, not even the cap is necessary. The fact is that it should not be, because those funds should remain untouched and secured, and should no longer represent a risk to the bank itself. And I'd like a response to that.
So the state of affairs is that there is a legal framework that allows a customer who has not interacted with their funds to retrieve their funds after 15 years. And there are mechanisms and instructions that will guide the customer so they can access those funds. One. Two, there are legal obligations for banks to ensure that they put in place mechanisms that allow them to manage fraud risk, including internal fraud. There are legal obligations for banks to notify immediately the supervisor if there is an event at the bank that causes it to lose funds in a manner that's not consistent with its normal operating business, including fraud. There are no charges for dormant account fees, and the supervisor has evaluated every bank and assured itself that each of them have mechanisms to electronically verify whether or not an account is accessed by their staff in real time. So I would want to know what precisely would be the mischief that is still left, for which which would need to be addressed via legislative amendments.
May I follow up with a question? So, could you clarify, Deputy Governor, the nature of the legal obligation devolving on the banks that now exist? And may I ask that in the event that it is breached for any reason, is the remedy purely regulatory, or can the depositor have a cause of action against the bank?
All right, so a breach of the Banking Services Act in relation to the obligation to ensure that they're operating in a safe and sound manner, which would be the case if an account of a customer is being accessed in a manner that is not consistent with its operating procedures. There are sanctions that are in the Banking Services Act, in the schedules, that would treat with a licensee who is operating in an unsafe and unsound manner. There are specific guidance notes which have been issued to the industry which require them to have the mechanisms and the governance arrangements to ensure that their entity is not being used as a mechanism to commit crime. When a staff member is involved in internal fraud, there are actions that the bank itself will take, that's a licensee, and there are also actions that the police will have to be brought in to take, because it is also a criminal activity. So there would be several lines of sanctions as deemed appropriate for the specific details of the case at hand. If it is a widespread breach in the systems and the structures of the bank, then a fine of the bank would be appropriate, of the licensee would be appropriate. If it is a mischief that was, or a deficiency that was exploited by a staff member that is peculiar to that system but has only occurred once, then perhaps the action of the board of the bank to dismiss or have the officer dismissed and handed over to the police would be deemed appropriate. In all instances, they are required to report to the bank under Section 39 of the Banking Services Act. So there would be never a matter where a customer account has been treated with inappropriately that the supervisor would not be made aware, and made aware in writing. What we have done operationally is, because there can be a number of fraudulent attempts which are unsuccessful, or they may be small, we do allow for those to be aggregated and reported to us. But certainly internal fraud is a specific writing to us on that particular matter. So that's a framework that exists now and treats with the fact that such incidences will be treated with as quite serious matters, which travel with sanctions as appropriate by the details of the particular case.
So Deputy Governor, would you agree with me then? Would you agree with me then?
Member Hilton,
That,
you could talk a little
sir.
bit louder. We're not hearing you clearly.
Oh, I'm leading. Can you hear me now?
Yes.
Deputy Governor, would you agree with me that of all the sanctions you've outlined, they are regulatory and criminal sanctions, but non-civil? That's a question. And would you,
that is correct. There are regulatory sanctions and there are criminal sanctions that are applied.
But non-civil?
Non-civil.
Well, Deputy Governor, I'd want to submit to the committee, through you, Chairman, that where the depositor whose money is at risk and who would have suffered some kind of loss from the actions of bank staff, isn't it reasonable that the depositor could look to recoup that loss other than through criminal and not be satisfied with simply regulatory and criminal sanction?
To be clear, in all cases, the customer account is brought back into order and the liability is borne by the licensee in all instances. So there is no instance in which a licensee could remediate the event of an internal fraud matter and the customer not be made whole. Once it is established that the customer was acting in accordance with the terms and conditions of the product that they had signed up for, and it is established that that account has been tampered with, the licensee remains with the obligation to make the customer whole. There would be no, after that investigation has determined those two facts, the outcome would be that the customer is made whole. So once those two things are established, that would be the state of play.
But I'm hearing, but may I ask further that sometimes, and I'm not clear, you may want to be a bit more specific as to what making whole mean, because sometimes when the criminal acts occur or breaches of internal mechanisms in the bank, there are damages resulting from that. Now, under your articulation of the customer being made whole, would that include, and my specific question to you would that include damages to the customer resulting from the criminal or other actions by the bank staff?
So the specific response to that is that not through the current mechanisms. The making the customer whole means returning the customer's account to that which would have obtained if it had not been tampered with. To the extent that that is returned or the funds are replaced and those replacements are borne by the licensee, then it would have met the criteria of making the customer whole. To include, just to be clear, to include the opportunity cost of the interest foregone, right? So as if the account had not been infracted. So to say that. So those are also compensated. Right?
So Member Hilton, may I ask, come in here and ask a few questions?
No, Chairman, let me just, I have a line.
This is your last one, so that I can ask some questions and other members can ask questions.
Obviously, but
all right, go ahead. Go ahead.
which I need.
Go ahead and
Thank you.
complete your
Thank you, Chair.
questions.
Thank you, Chairman. So, Deputy Governor, would you agree that in circumstances in which this mischief has occurred, the money is disappeared from the bank for whatever period of time, including the time for investigation and all of this, before the money is put back into the account and interest foregone is included, that the customer could have suffered serious economic harm by loss, and the loss opportunity is not simply restricted to interest foregone, but he could have suffered significant damages for which he can prove that, but for that mischief in the bank, he would have secured an opportunity to which he has lost and has been injured in that way, and damages resulting from it. And I'm suggesting that in those circumstances, the customer should be entitled to pursue a claim against the bank and its employees for these damages.
If I may take two approaches. One is to say that in instances where the customer feels aggrieved, then there are mechanisms under the Code of Conduct where they can write to the licensee and identify the specific matter and what they deem to be an appropriate redress. If they have not received a response from the licensee, I think the licensee has a specific period of time under the Code of Conduct to respond to them. If they haven't, then the member of the public or the customer can write to the central bank, and we would then, as it were, intercede, communicate the concern, and the bank require the licensee to respond to the complainant and copy the central bank. So that's the mechanism that exists now. If that does not lead to a satisfactory outcome for the customer of the bank, they still have redress to the courts. So they can still go to court and say that they still feel aggrieved in spite of the response or the actions or non-action, as the case may be, of the bank. So that is there's a two-tier mechanism. The customer would first go to the bank and make their complaint. They would, if they're not satisfied, they would come to the central bank. We will intervene. And I can say in most cases that the banks, within the spirit of good customer relations, would typically try to accommodate once there's evidenced facts supporting the complaint, and failure of which the person still has recourse to the courts. So that would be my response.
But my comment, Chairman, on this particular issue is that in these circumstances, where there's a particular mischief and a particular set of injury resulting from the conduct of the bank and the staff, that I believe to put the customer in a situation where they are either at the mercy of the bank or the governor or the supervisor, and not being able to have the matter specifically addressed before the court, other than through a generalized breach of contract or some kind of tortious action. I believe there is a responsibility on the Parliament and the government to address this particular mischief in particular ways, so that the customer does not have to be put at the burden of going through a costly court action, which itself is a deterrent to many of the customers who use the banking services. And so I believe it still remains a matter for the Parliament and the committee and the government to address in these circumstances where the confidences, the trust of the depositors is breached and damages result. I believe there should be a mechanism for some sort of quick resolution, because we have deemed that to be a cause of action inuring to the benefit of the customer. And I'm making that such a recommendation, Chairman.
Thank you, Member Hilton. I have a few questions, and I'm sure other members have some questions, but Dr. Lewis, in your presentation, you said in the past there was 2 DTI that had applied dormancy fee. How far in the past was that?
Yeah, so I would say back in 2017-18, it wasn't just 2. It was actually more widespread than that. What I was saying is that 2 of them were on record for indicating the reason why they stopped charging dormant account fees. And then it was adopted more widely by the entire sector.
And so I have follow-up questions. So was it within, when the BOJ as an oversight body, was it within the contract of those customers who would have engaged with the bank for dormancy fee to be deducted? Because many times we would have gone to the bank and we get a number of papers and we signed not knowing what are the terms. So in essence, a Mass Everall, a Miss Teeny would have gone to the bank and opened an account. Did you find that in these contracts there were elements that said that the banks could charge dormancy fee?
So typically there are 2 mechanisms. One is that the bank in issuing a new product, yes, there will be terms and conditions, and those terms and conditions can either be explicit in naming all the fees and stating the consequent charge, and in this particular case with a dormancy fee to be a contingent charge. So it would be if something does not occur, then a charge would be levied. So in the past, how agreements were stated or set out, they would simply put a provision indicating that they could charge fees. What the Code of Conduct, which came into effect in 2016, required is that on signing, customers are aware and sign to indicate that they know the specific fees and charges associated with operating that account. And so the practice would have changed in the industry post-2016, where on account opening, the banks have an obligation to ensure that the customer signs to indicate the specific fees and charges and associated with the product and the conditions on which those fees and charges would change or could change. That's 1. 2, under the Code of Conduct, the entity, if they're going to change their fees, they are required to notify the customers and give them 45 business days before they change the fees, right? So what that means is that during that 45-day period, if the customer feels that the account or the product no longer fits their own specific needs, they can change to either a different product within the same financial institution, or they can change to another financial institution. And so we have provisions on the Code of Conduct where, 1, at the beginning, it's not just general statements about what that fees could be charged, but they're required to indicate what those specific fees and charges are. And 2, if they're going to change them, they're required to indicate and give their customer time to adjust and make a decision in relation to a new fee or charge.
But the second part of my question was the Bank of Jamaica. Have you found that in any instance that any DTI had not included these contingency fees in their contract and were charging them?
In our supervisory process, we haven't come across any of those cases. Where we see complaints coming from members of the public in relation to a licensee, and we find that the licensee has not acted in accordance with the code of conduct, then the licensee is required to give redress to the customer. So that's how we would treat with that particular matter. But I can't say that in our supervisory review, we have come across cases where the fee was not made disclosed prior to the engagement with the customer and then is subsequently implemented. We haven't come across that. Typically, however, and these are matters which are in the space of market conduct and consumer protection, typically the information around these matters will come from our customer complaints, right? So it will be members of the public who will write to indicate their experience, and then we will follow up to ensure that they're treated in accordance with the code of conduct. That's typically how the mechanism operates, which is very different from the prudential side, where we are inspecting bank accounts and looking at balance sheets and audited statements. It's a slightly different, so we would be more investigating the business model of the licensee. In these matters, we typically rely on the members of the public to make their complaints, and then we do our interventions and ask the licensee to give a response to the customer.
A further question I have. Where there have been complaints about these dormancy fee, if you have received them, and I'm sure the bank would have received complaints. In your review of these fees that have been charged, that would have been in line with the agreement that a customer would have signed, do you find them to be reasonable? Because I note earlier it was mentioned that bank charge for services, and your review of these services that they would have charged for in how they have coined it is not illegal. The question is, in your review, do you find that some of these fees are reasonable or unreasonable in general?
Okay, so it's difficult to answer the question around dormant fees because there's no licensee that's charging for dormant fees. So I think the issue is a non sequitur.
Let me just, during the time, if you had prior to 2017, if there were
So the chronology is important, though.
Yes.
So there was a mischief in the market. The central bank would have addressed it by promulgating a code of conduct to which all licensees would be obligated to act according to. And then since then, we have been managing the complaints as they come in and taking on a case-by-case basis the matters that are being brought before us. We don't have a framework at the central bank at the moment that evaluates fees and charges, right? So the reasonableness of fees and charges is not a framework that either we have a mandate for or we have a mechanism or a framework for. The things we will look for under the code is whether or not the customer was aware, whether the customer agreed to the fee, whether or not the fee is being charged in a manner that's consistent with the contract. That is our realm of engagement on the matter of fees and charges. We don't get into the aspect of it to determine whether or not it's reasonable or or so on. The advice and what we try to do in terms of public education, using channels such as Centrally Speaking and other outlets that we have to communicate to the public, is to say that they should shop around, inform themselves, and then make a decision as to which products and services, financial products and services, best suit their own particular need. And typically banks have a suite of products that are addressed to different customer segments. And so we encourage members of the public to look carefully before they sign the contracts to make sure that the product that they're selecting is consistent with their lifestyle, their economic means, etc. So that's the framework that exists at the moment.
But just to close out this, I can imagine members of the public who are listening, and you know, they are saying, do you at BOJ, do you in Parliament understand the documents, how many leaves that we have to pour over to read through? Or is it that we say in a reasonable kind of way that this person who is at a basic level, and even some persons who would have gone through even terminal degrees, will find it very difficult to go through all of these documents. To say that they would read it through and understand everything. Is there a way that there are just some elements that these DTIs can just put up front that is central to persons doing their banking? Can we see that any at all?
Under the Code of Conduct for consumer-related matters, there is an obligation of licensees, banks, to express terms and conditions for products in simple and clear language. So that provision is there. Where we have received complaints from members of the public, where they say they couldn't understand or they didn't understand, and when we look at the documentation and we see that, in fact, it's, that is a reasonable thing, because they would typically, a complainant attaches the actual substantiating documents, and we do have officers that look through those. And where we see that it's a reasonable argument, we then write to the licensee to say, how could the customer have understood this possibly? And we insist that they treat with the matter in one that is fair to the customer. So I'll give you some examples, and of course, data protection, so we won't mention any names. But if at the signing of the contract, the customer understood the interest rate to be one thing, and it turns out that the bank made a mistake and it should have been another rate, we insist that the bank, to use a colloquial term, hugs up that rate. Because the fact is, the customer, in signing that contract, would have been led to understand that this is the rate at which I am contracting at. So we do intervene where necessary. But of course, these interventions can't be public interventions, because they are private matters between the customer of the bank and the bank itself. But we do have that. We would have processed over 400 complaints last year, and gone through each of those and made significant attempts to close those out. And by and large, when the complaint is substantiated by evidence, we will stand with the customer, right? But what we have to be careful of is that it has to be on a case-by-case basis, because there are other cases where the customer has not acted appropriately. So if you share your PIN with another family member and that family member uses the money, you cannot turn around to the bank and ask the bank to give you back the money because you would have broken or breached the terms and conditions of the product. So it's a case-by-case. These matters of consumer protection are a case-by-case matter. It's very difficult to say in all cases you're going to make or insist that the customer be made whole. You have to look at the substance of the matter that is before you and aim for being reasonable. The final thing I will say on this is we have required that banks post interest rates in a manner that allows customers to compare interest rates across the financial system. We call it the effective annual interest rate. And so it's something that we want to introduce in other sectors, and I think the microcredit sector also has it, where yes, you can advertise a daily rate, but you must let the customer know what that rate looks like if it were to perpetuate for an entire year. And so those are disclosure mechanisms that are embedded in the code of conduct. So in many cases, the issue is enforcement and making sure that we enforce what is already there rather than trying to come up with a new law, but enforcing what exists and making sure that it works in favor of the target market or the target audience it is intended to protect.
Member Wilson.
Thank you, Chair, and thank you, members from BOJ for coming in. You started one of my questions, Chair, and I wanted to follow up on it as it pertains to the agreement that are being signed. Because I understand your response. It's in the agreement that dormancy fee can be charged. But similar to the case, that's why I asked this at the last meeting, similar in the case of other Caribbean territories, there is no upper limit. And I think that's where the challenge is, because we know that in operating any institution, there will be charges, there will be costs incurred naturally. However, I think it's the limit that is a challenge, not that persons are being charged. And it's like saying to customers, how long is a string? Just signing an agreement saying you'll be charged dormancy fees, I think it's a very broad scope, and it opens our people who are looking to save their money to exploitation. That's how I see it. And for that reason, I think everyone is uneasy. Despite that being changed now, I think the unease for everyone is that the charges were just sudden in a lot of cases and was extreme. And that is the perception that's out there. And I just want you to understand where I'm coming from. And I think you guys are doing a fantastic job, by the way. But where some of these loopholes are, it can be detrimental to the image of our financial sector and even to us as politicians, because people will see us as not doing our jobs. So with that being said, the idea where we are now, because you said dormancy fee has basically been suspended, quote unquote, where we know, is there an upper limit to charging dormancy fee if there is still dormancy fee being charged? Because I heard your statement earlier that the dormancy fees would have been suspended, or there are entities that have digitized their operation, which would have resulted in them not incurring administrative costs in monitoring dormant accounts. So I want to know at this moment, for John public to know, is there dormancy fees still being charged? And if there is across the sector, is it that some institution decide not to, or is it that BOJ has instructed them that, listen, that should not be something that's within the operation, the scope of your operation? So I want to answer there first, and then I want to go to something else, a few other questions I have.
So just to say what exists now, as it exists now, all licensees are required to submit to the Bank of Jamaica on a semi-annual basis their list of fees and charges for all their products and services. Those are put on the BOJ's website and is accessible by members of the public. Banks also are required to put their own fees and charges on their website so that members of the public are aware as to what the costs associated with using their facilities or their products and services and financial channels. We do not have a mechanism for issuing ceilings or floors for accessing financial services. We evaluate each licensee's business model and ensure that that business model is consistent with them being able to operate safely and soundly. And primarily for banks, the critical question is that when a customer comes to one of its channels, whether it be an ABM, which I know we'll get to shortly, or it be a branch, and they make a withdrawal, they get the funds as long as those funds are cleared in their account. So that's the framework that operates now. So we don't issue to DTIs limits, whether there be floors or ceilings in relation to products and services that they offer. What we supervise now is to ensure that if they're launching a product, they're launching that product in a way that doesn't bring the financial institution into disrepute financially or allow the entity to be abused as a means to facilitate money laundering. That's the scope of our interactions. I would have said it earlier, but I think it bears repeating. There's no financial institution that is charging for dormancy fees, and they have said, not us, they have said the reason why they are not doing it is because they have become more efficient, and therefore they are leveraging technology to allow them to offer these accounts, keep those accounts, but at low cost. And so there's no more need, therefore, for them to charge for that particular compliance cost. And that's the explanation that is given, and the central bank will continue to provide updates in terms of fees and charges as time evolves on a semi-annual basis.
Thank you for that. And I'm pretty sure the public will be happy to know that dormancy fees has been suspended. Now, you said something earlier that as technology evolves, the banking service will adapt these technologies and they will become more efficient. So, in our prosperous Jamaica that we're looking at, we're looking for fees to be reduced, not increased, and for savings account to actually bear some level of interest, because you did indicate that the banks are now required to post their interests that are being charged and interest on saving accounts as well. So we are hoping that that will be a turn. And I like where this is going. Going specifically to member Celeste, right. You said something earlier about the description of savings account. And you had said in the Banking Act that savings account is not defined, but rather deposit account. Okay.
Can you hear me?
Yeah, go ahead.
Yes, we define what a deposit is. So it's a sum of money that is given to the bank on terms and conditions on which it will be repaid. And some of those conditions include whether or not interest will be paid on that account. And it is not associated with funds paid over to a bank for a service, a fee, or as a conditionality of a loan or so. It is simply monies paid to the bank to be put in an account. So that definition is in the Banking Services Act.
All right. The reason why I find that very interesting. Reason being, if within the Act, it's just accommodating deposits, or it is broadly defined as deposits, it would then translate that deposits to an institution may not bear any interest. Because the general thinking out there, and you have to understand that the general Jamaican out there, when they put their money into their bank, there's a natural, basic assumption that we're going to make some money. I mean, it's kind of moving now because we understand they're not making any interest. But within the context of the law, my concern is that it did not define that you should put your money in a bank and you will get interest.
That's correct. It just says you can put your money here on terms and conditions, and one of those set of terms and conditions is that you can get interest on the account.
So interest is optional?
Yes, based on our definition of deposit. But typically, interest is charged. But
Right.
that is the definition in the Banking Services Act, yes.
Right, so, you know, I'm an MP and a university graduate. I totally never understood that, and I'm pretty sure a lot of persons would not understand that within the law it is not clearly defined, and there's a natural assumption. So just to push a bit on that point, so deposit will also include investments. So you look at
no,
okay.
No.
It would not.
No, so the deposit is a specific arrangement that you have with the bank, and it's monies that you deposit in the accounts there for the specific purpose of leaving the money there, and the bank has the wherewithal to use those funds, and their obligation is to ensure that they can repay it to you on demand. Right? If you are going to be making an investment, that comes with a different set of obligations. And the guarantee that is associated with a deposit, which is that you will get your money back, that doesn't happen with an investment. An investment is a risky undertaking. And at that point in time, it's buyer beware, and you take the risk of that investment. So it's a different arrangement, and so the Banking Services Act is very clear. It's not dealing with investment arrangements.
All right. Very clear, and I thank you for that. So the assumption that we have that we would deposit money into an account and it will bear interest, because there's an issue of how Jamaicans interpret the term dormant. If I put my money into the bank, the deposit-taking institution, and it should be earning interest every year, whether I did or not, whether it's $1 or $10 or $100, it's still earning. How would that constitute my account being dormant? Because the mere fact of me putting my money there, the bank should be using it. And I'm pretty sure the bank is using it. So how can that now be dormant if the bank is using the monies that I would have put there to, and it should be bearing interest? That is...
Right, so remember now, dormant is not a part of the banking services framework. It is actually a terminology coined in practice by the banking sector. In our code of conduct, we recognize that practice, and I think we speak to a period of nothing happening for 6 months. And it's really on the part of the user, the holder of the account, the person who owns the account. So the inactivity is on their part, not what the bank is doing as to whether or not fees are applied or whether interest is accrued. Okay. It's on the holder of the account. So remember, the account you're supposed to be using the account.
Right.
You're supposed to be seeing some activity on it. If nothing is happening and they're not responding to your request for updating information, nobody is responding in any way, nobody is coming to it, then if that is the situation that obtains for 15 years or more, then it gets classified as unclaimed monies, and then it is subject to the treatment that is outlined in the statute. And you don't get disenfranchised immediately, but what happens is that the methodology by which you can claim that money, it changes. So you don't go to the bank, you would then have to go to the government through the mechanism that is outlined in the Act.
Okay, understood. So in my interpretation then, dormancy would evolve by the depositor not interfacing with the bank for such a period. All right, a period, and I think a lot of people would appreciate that. Now, I have situations, and I've known of situations where persons have gone overseas and they would have been saving in an account in Jamaica. You know, they are from the diaspora, they are sending money to an account here, they are planning to retire in lovely Jamaica, this is where they were born, and they would have been depositing money over a period. And the mere fact of depositing, would that in itself break this whole threshold that you have of dormancy? That's what I want to know.
Yes, it's a transaction.
So once there is a transaction.
It's a transaction. It's an activity by the holder of the account. So yes, it would break that.
All right. Thank you. All right, one more question, Chair. I think you give Member Hilton a lot of questions, so I think I can go with one more. So, yes, Ms. Dr. Deputy Governor, you mentioned something earlier which was very key, and it underscores the work that BOJ is doing. You said 400 complaints came in. Did those 400 complaints, and were these, just a basic demographic description, were these pertaining to dormancy fees? I know, but he said complaints. So I just wanted to, just a breakdown of the type of complaints, and comparatively, prior to the new standing of BOJ, where the banks and the DTIs have now ceased dormancy fees, would you have seen a drop in number of complaints that would have come in from what I would say, depositors?
Okay, so let me take that on. So I can't give you the specific breakdown. What I can assure you is that every year we, in our annual report, give a very detailed outline of all the complaints that come into the central bank. So you can rest assured that assessment is being done. What I can say is that there was quite a significant increase in the number of complaints. So in the previous year, 2022, complaints would have been about 290 plus, and last year it would have increased to in excess of 400. So we are seeing an increase in the number of complaints that are coming to us. Some of that is as a result of greater sensitization of members of the public to the fact that the Code of Conduct does allow them to reach out to the central bank in instances where they are not accessing or receiving the responses from the licensee. So we will intervene in those instances. Some of that is related to, well, if I were to decompose it, again, I'm going from memory here because I don't have the report. We were seeing a number of complaints in relation to frauds, and I think the last time we were here in this committee, we would have spent the entire meeting discussing that, so I don't think we need to go through that. There were complaints in relation to ABMs, and I think out of that we would have implemented the standard of sound practice in terms of minimum service level standards for ABMs. And I believe the other area that was mentioned or featured, so to speak, had to do with transfers from one bank to another bank. So sometimes there are transfers that would go and it's credited to an account that's not intended, and then the remediation of that process. But we do have the breakout by category. So I think we have about 7 or so categories of complaints, and we do give the trends over time. What we do is look at those trends and determine whether or not, particularly where we see increases, we then look at whether or not we need to give better guidance to the licensees, and certainly becomes a part of our ongoing on-site supervision of the sector to look at those issues. Because what you want to make sure is that there's not a systematic deficiency at the licensee that's causing the complaint. Because you don't want them to just remediate the complaint. What you want them to do is you want them to fix the problem that generates the complaint. And so we make sure that when we do our on-sites that we look specifically at that issue. Because it's one thing to remediate the customer, it's another thing to have 10 more customers come in and have the same exact experience.
Thank you. I guess we now move over to the a good segue, minimum service standard for our ABM. Can we get an update, please?
Before we do that, can I ask a question on the dormant account? Governor, as you have done the surveys for the fees in the banking sector in the region and perhaps beyond, have the BOJ done any study or any survey on the dormancy fees and the length of time in which the fees, before those fees are classified as dormancy fee? And I ask this question because it has been pointed out that, and it was more urgent when the fees were being collected, wiping out the account in many instances where people are there saving for their funeral and all of that. They go back, and when they go back, it will be totally wiped out. So it was very urgent to stop that charging on the account. And the theft issue is being minimized, I'm told. But then there's a broader policy question as to whether the 15 years is not in keeping with best practice, and that shorter periods of time before it's classified are more the norm than exist in Jamaica. Do you have a view on that, Governor?
Okay, so no, we haven't done a study like that. But what I can say is that there's a difference between what in practice is termed as a dormant account as against what is an unclaimed monies account. So unclaimed monies account can include the dormant account by virtue of the timeline applied. So the timeline for unclaimed monies is 15 years and over, no activity on the account. In our code of conduct, based on interactions with the banking sector in Jamaica, the period that typically applies to the classification of dormant account is 6 months, not less than 6 calendar months, where you have no activity whatsoever on the account. But no study done in terms of timelines that apply to the classification of dormancy, the label dormancy.
Or unclaimed funds, but for the unclaimed funds to be then eschewed to the government, which is 15 years.
Yes, they have a longer timeline for unclaimed, yes. But we don't have it here, but yes, I think I saw that. So if you could just repeat that question, I'll see if I can answer that one again, please.
No, I'm saying I thank you for the clarification with the dormancy and the unclaimed. And so whereas dormant funds are classified at 6 months inactivity, unclaimed funds are allowed to remain with the banks for up to 15 years before they eschew to the
government, yes.
Consolidated fund after the minister has gazetted and done some notification.
Right, that's correct.
And so your answer to my question is no such survey has been done.
Correct.
Okay. All right. Thank you.
Update, minimum service.
Yeah, just to introduce the issue. As you know, we consulted with the banks and established some standards. The banks will tell you that these standards were a stretch for them, and indeed they are. And the intention was that they would achieve them over a period of time. We have published a couple of months of reports on these machines by bank, by geography. We have seen improvements over the months, and then came burial. And that has been an obvious setback. And in the presentation, I'm sure that Dr. Lewis will speak about the impact of Beryl. But generally speaking, I think that it was a good interaction with the banks. I think they were seized of the importance in the public's mind of raising the standards. And they agreed to cooperate, and that cooperation was actually in action until Beryl came. We have the challenge now of building back to those standards. And until we can get power back, internet back into all of the communities, we're going to see that these standards remain fairly low. And what you'll see is that some banks have a higher concentration of ATMs in the affected parishes than others. So smaller banks may look like they have very good ratios compared to the bigger banks that have in St. Elizabeth, Clarendon, Manchester, Westmoreland, a lot of branches. But eventually, I think we'll get back up to those levels. Jide?
Thank you, Governor. Yes, just to proceed, we had seen improvements and have been seeing improvements in terms of service level standards for uptime and for availability, cash availability. Recall that under the standards, all banks are required to have 90% of their ABMs operating in any given month, and they're required for those ABMs to have an uptime of 95% or more. And what we had been seeing, I think we've just put on the website the April report. So from January to April, we were seeing steady improvements in terms of both the number of ABMs. I'm happy to say that currently 884 ABMs are operational installed across the island, and that's an increase over time. To take you back to 2016, there were 571 ABMs across the island. And back in 2020, there were 791 ABMs installed across the island. There are now 883. So we're seeing a continued increase in the install levels. What the standard does now is makes it, enforces the requirement to make sure that if you install it, it is working. And so 90% of that 883 ABMs across the island needs to be working at any given time. And then if it's working, it needs to be working like a 24-hour machine. So it needs to have an uptime, as measured by 24 hours, of 95% or more. And what we were seeing in the results when we looked at it up to April is that most entities were meeting maybe 97% of their ABMs were operational in any given month. That's the median. And we were seeing uptimes that were trending between 92% and 93%. Not quite at the 95%, but we were seeing, recall when we started, the uptime would have been 89%. So it has crept up from the 89% uptime to the 92, 93%. And they were on their way to the 95%. Of course, Beryl would have struck, and we have seen where the entities are now in a rebuilding phase. So the update that we would have received up to yesterday would say that number of ABMs that are operational are varying between 87%. I think the lowest percentage is 68% for one of our larger banks. And the highest would be 90%. So the range has now fallen between 68% and 90% as the range, as against pre-burial, which would have been somewhere between 88% and in terms of uptime and 93%. So the main issues that they have cited coming out of burial is the availability of electricity. They cite the issues of internet connectivity as the major issues that are plaguing their ability to have these machines up and running. They do have UPS and backup, but those things last for hours, not days and weeks. And so that is going to be a constraint. I'm happy to say that All branches across all DTIs are open, but just to advise the public that the quality of service may not be there because, of course, if power goes during the course of the day, maybe the AC machine is not working, perhaps the system is running slower, but the branches are open, right? All branches across all 11 DTIs are open to the public. Where we're seeing the degradation in terms of service delivery has to do with the ABMs, and it will take them time, and it will be heavily related to how quickly the provision of electricity and the provision of data services will be brought back on stream and come to normal. So they can't do more than, it's a binding constraint, they cannot do more than those fundamental, what we call critical services, ability to provide the support to let the ABMs operate. We did have a few instances where ABMs were attacked. We did have an instance where an ABM was robbed. And of course, that those things are things which are deeply regrettable. So the sector is looking at ways that they can tighten on the security around these, but of course it poses challenges. So again, it's a delicate balance, making cash available while protecting what ultimately are deposits, right? So we have to understand that it's the depositors' funds that are then turned around and used to facilitate the ability of the wider public to access funds via ABMs. So it's an appeal, I guess, for persons to understand that, you know, if they're taking funds from an ABM, you're taking depositors' funds, ultimately speaking. That's what it is. It's not new money. It's the same depositors' money. So that's where we are. We have given each licensee up until the middle of next month. I think we have given some extensions to write to us their plan, their board-approved plan as to how they're going to meet all the other requirements under the standard of sound practice. And we're expecting that those reports would come in. We'll evaluate them and see to what extent those timelines will fall within the transition period that we had issued, which was up to November of this year. Again, because of Beryl, some of them might be delayed by a few weeks, a few months. So that's something that we have to bear in mind because we all live and work and exist in Jamaica, so we know some of the realities. Thank you.
Thank you. Member Lawrence.
Yes. Yes, good afternoon. On the issue of the ABMs, as a rural MP, we always have challenges with ABMs for one reason or the other. As I mentioned, maybe even before burial, you may have the downtime in terms of internet and so forth. But generally, I believe, especially my constituency, which is Westmoreland Eastern, I believe the downtime is completely different from other places. Reason being, if a machine in our area, well, at least it was one in the entire constituency. It was 3 at one time. So it actually leads me back to a question where I actually didn't even remember that I should ask. So let me just jump back to it. Does the Bank of Jamaica help to regulate the spaces where the ABM located, or just the institution itself decides on that? And if, for instance, it may be done through breakage, they just pull it out of the space just permanently without even making mention or even considering the level of customer that usually use it. They just move it because of breakage and, you know, no intention of putting it back. So I just want to know, question by question, if Bank of Jamaica really have anything to do with the locations, and if there is a regulation that once somebody come in and do any breakage, the bank just decide to just move it and it just gone permanently.
Okay, so the standard that has been implemented since April of this year does require licensees, banks, to do an assessment, a risk assessment, before they put in an ABM in a particular location. And that risk assessment is to determine whether or not that location would pose a risk to members of the public and also risk to their infrastructure or their assets, which would be the cash that is in the ABM. So we don't require licensees, banks to put ABMs in specific locations. The business model or the strategy of the entity will determine where they put their ABM infrastructure. What we can say is that we observe that more ABMs are being installed outside of branches vis-a-vis ABMs that are installed in branches. So it appears that the strategy overall of the sector is to allow for greater access over time. I think the challenge is that even as they're pursuing that strategy, there are cases where the investment is being impacted negatively by incidents of theft, both cash in transit and also at the ABM itself. In fact, over the last 12 months, there have been at least 10 instances of attacks on ABMs or cash being transferred to ABMs, which we call cash in transit attacks. And so it's not something that is, it's becoming systematic rather than something that is sporadic. And that's a problem because then it then has to feed into the decision of the licensee to make the investment. It affects the return on the investment. So I think it behooves all stakeholders to play our respective parts in ensuring that the environment is conducive to the further deployment of more ABMs in more locations in a way that is safe to members of the public on the one hand and is safe to the entity that is offering the financial service to the public. So if I could summarize, we don't dictate the location of ABMs as a regulator. What we dictate is the process by which they would determine where they will put the ABMs, that they do a risk assessment, that they make sure that the ABM is safe, that they put in the necessary mechanisms to determine that the ABM is functioning. And if they make a determination to remove the ABM, they are required under the standard to notify the central bank prior to receive our non-objection. And then if they do receive our non-objection, then they can proceed to remove the ABM. And typically we would evaluate the case that is made for the removal of that ABM. Of course, if a licensee puts an ABM in a location and it is not serving the public and it's being vandalized and they write to say they'd like to remove it, it's very difficult for the regulator to object because, you know, it puts us in a hard, difficult position because there's a reason or a rationale. But certainly we wouldn't want arbitrary removal of ABMs across the island. It has to be justified in the same way that they would have justified the build-out of the network. They're required to justify the dismantling of the network. So that's the framework that exists currently under the service level standards.
Okay, well, we have 3 in the entire constituency, and all 3, well, 2 has been removed already, and it was maybe through each one single theft. So, you know, really give a rotation in terms of second chance, just one single time. So I'm just wondering if, you know, you just move that easy. The constituents in general don't really have a say in terms of wanting it to be there, having the access of it. The bank just make the decision just totally based on bank security. What we are saying is that when you assess the level of customer who need the service, for instance, an area like even Darliston in my constituency, it's actually in the center of the constituency. People from that area would have to travel either to South, which is about closer to 30 miles, or Montego Bay, which run up closer to 35, 40 miles. Black River will be the next area. So they are actually, an ATM machine was there. And then just, one time it's breaking, and then just move it out of the space completely and leave everybody. So for a person there to get the service, and bear in mind that most people get their pay through their account, to move all the way to Black River, Montego Bay, Savlamar, it is not easy. The cost just to retrieve a small money for even grocery cost them a lot. So we are just wondering if, you know, maybe the Bank of Jamaica also could look into something more specific like that to protect customers in those areas, even if the bank decide to move it because of theft. We realize, we understand that they have to protect their interests, their security. But at the same time, generally, as an MP, I really want to protect our constituents.
I totally sympathize with that situation. To live in a community and the nearest ABM is 30 miles away is crazy. On the other hand, for the financial institution to have an ABM, some of which costs $500,000, US dollars, not Jamaican dollars, vandalized or robbed, it's natural for them to want to protect it. So the banks and the Minister of Finance were in discussions about ways in which the government and the banks can cooperate to make sure that the distribution of ABMs throughout the island meets customer requirements more, even when there is not a good economic case, or where the private sector can't find an appropriate and secure location. Right. So government may have offices that are secure. They may have police stations that are secure, that ABMs can be put in. And to the extent that the government and the private sector through the banks can cooperate to do that and enhance the distribution. And that's the road and the path we're on before Beryl. We saw this improvement in the ATM uptime, and we saw the talks going on between government and the banks to get this kind of enlargement of the network. So that's where we want to get back to, because I think it's totally inappropriate to have a community without the service of an ABM. And so I know you, in your constituency, could find a couple of locations that are secure and could be have an ABM installed if there's cooperation, and even where the economic substance is not there, to the extent the government is prepared to work with the bank to install the ABM. So we hope to continue that discussion and get some positive practical action done.
We have one work off and on, and I am sure that it is way out of the downtime, sometime for weeks. One in White House, sometime for weeks it is out. Presently, it is out since the hurricane, and up to this point, it is not yet back.
how to advance this idea. Is it that the members of parliament who are more sensitive to this issue, because they're on the ground, should say it too, say the Minister of Finance, here are a number of locations that we think would serve customers in the area better as well as be secure, and would you discuss with the banks, whichever of them, to put machines in these areas, rather than the banks searching around and saying to the government, I'd like to put a machine in this location, will you work with me? You see what I'm saying? I think the MPs are in a better position to initiate that process and bring it to the attention of the banking community through the Minister of Finance or the Bank of Jamaica. We're happy to play that role to coordinate it along with the MPs.
Thank you.
Chairman?
Yes, sir.
Member Wilson and then Member Hilton.
All right, thank you, Chairman. And going back to Dr. Jide, you mentioned something earlier about 90% uptime and running, and I totally will accept the report. The challenge within my area, similar to what member from Eastern Westmoreland alluded to, is that those numbers don't spell the reality within the rural communities. And if you think about concentration, I'm going to use that word. If you think about the concentration of ABMs across the country, you may find that, you know, the urban areas, Kingston, probably Portmore, Montego Bay, may have a greater concentration. So with all the ATMs working in those areas, you may get a 90%. However, where they serve what we'll call rural areas or areas that are less populated, one ATM will be serving, in terms of square, it's going to be a lot. We're talking about probably 50,000 people, 30,000 people within a particular geographic space. So in Westmoreland, the highest concentration of ATMs would be in Sablamar. In Negril, where I represent, we have 2. Right? And Negril, capital or casual, we have 10,000 hotel workers, accounts or something close to a third of tourist income. So it's massive. We have only 2 ATMs. So even 3 now, 3. 3. So within that context, when one goes down, you have these lines that goes in perpetuity around the building. And they stand up in rain waiting for hours to use the machine. And this goes not just from 9 to 5, but it goes right up in the night. People are just lying in there queuing. And what compounds the issue is that we have the DTIs removing their footprints. So, you know, they don't have branches anymore where people can access. And where they do have branches, they have something new called non-cash branches, which means you cannot get money. So money has become somewhat of an elusive creature, in that the access to it is now far, far reduced. Now, I understand risk. It's a part of operation. I understand the banking sector and money. I don't understand everything about security, per se. But I do know that the bank has to take their precautionary measures, and they have to build that within their business model to finance it. However, for the common man, which we are serving, and when I continue to use that term, it's becoming increasingly difficult for you to get your money, the same money that you put into for safeguarding and safekeeping, is now becoming difficult for us to engage in the formal sector to be a key component of the banking world, because you can't get the cash. You can't even bring your cash in some branches now. And in some areas, such as Grangeville, the banks totally just remove their footprint. They just close the branch. So the challenge we are having is we are being pushed to to use ATMs, but we are just not ready. And when I say we are not ready, I'm not talking BOJ, because you guys are regulators. We are not ready in terms of the DTI has not risen their standard level service delivery to the people for them to be removing their footprint, i.e. the banks, the branches. So my challenge is they are allowed to remove the branch, right? And it's not just the banks is doing it, other entities as well. And they put an ATM there, and the ATM is down for 2 weeks, and they just leave it. And they said, 90% is up because all of Kingston is up. That is unacceptable, right? So the challenge I'm having in my neck of the woods is that the numbers are not speaking to the reality of what's on the ground in my neck of the woods, because the numbers are just not there. We are part of the, well, and by the way, this is not because of Hurricane Beryl. This is something that has been ongoing. So as my colleague member has said, we are part of that 10%, or that before Hurricane Beryl, we will be a part of that 7% that they consistently neglect. Because that's what we're that line through the cheese, if you know what I'm speaking about. So we are the consistent one that they neglect. And for that reason, I'm going to stop here. I'm saying look at the numbers, and when reporting, it could be segmented by parish, because, your 90% could exclude Westmoreland totally and St. Elizabeth. You could. So you could probably look at parish. That is just one off the top of my head idea of how we could look at the uptime for ATMs. But how it is playing out now on the ground is that they are pulling their footprint. The banks are closing, and then the non-cash banks, I don't know what they're there for, because they don't spell into the act of collecting deposits, as Ms. Celeste has said earlier, Dr. Celeste had said earlier. They wouldn't define because they don't collect deposits. So they're just there, and possibly soon they'll just move their footprint because they're not collecting any deposits. So that has become a challenge, an evolving challenge for consumers, even myself, because accessing cash now has become very, very difficult.
So we need to do something.
So I'm not sure who's going to take that one. It's kind of long, but it's very important.
No, the points you've made are taken. The report that we publish monthly.
Just before you answer.
Yeah.
No, that's all right. Before you answer the question, just to add to what Member Lawrence and Member Wilson said, perhaps even if you did the breakout into parish, you still have reports that there's a 90% per parish, because the urban area are working and are working effectively. But the rural space, and for this committee, you have mostly rural members on this committee. Let me just say. Right, Westmoreland, and I am from Clarendon Northern, up in the hills. And I take it that some of the challenges that is going to come back at us is the internet, that thing that is affecting it as well, because most of our ATM in North, which we only have about approximately two ATM in the space, and we really have downtime and machine running out of cash very quick, because it serves so many people. So if you could look, or if the banking institutions could just pay some attention to the rural space, and I take it that they are very cognizant of what is happening, because they must be, because they service these machines in terms of replenishing the cash and know what is happening in the space. But if we could really get some report, some breakout, not just a report, because the report will tell us what we already know. What we need is to see how best we can resolve it, and Governor Biles, I like your suggestion, and in fact, we think this committee will take it on in our report when we report to the House to ask the minister, to fast track the conversation with the banks and the government, and to see how best we can bring into that conversation the Minister of National Security, where some of these ABM machines can be placed closer to police station or within the space of police station where there is a high risk level, where the bank may do an assessment and the risk level is high per se, if these can be moved closer to the police station. So I really want to encourage that.
I believe that you've answered a big part of the question that was posed, because the standard having been implemented in April is not going to instantaneously change the deployment of ABMs. What it's going to do is change the performance of the ABMs that are already there. And it really is going to take some of the suggestions that would have come from the governor to change the distribution of ABMs geographically. The report as is does break out, urban, other urban, and rural. And by urban, it's speaking to Kingston and St. Andrew. By other urban, it's saying St. Catherine, St. Anne, and St. James. And then rural are all the other parishes. So there is an accounting there. And when you look at the results, you can see that the uptime for what is classified as rural, the lows are in the 85%, 80%, 75%. So we are seeing it in the data. So the reporting, I believe, is not really the issue. The issue is the objective reality on the ground in terms of the calculus of the risk and reward associated with deploying ABMs by licensees. And it really will take, I think, a collaborative effort between the licensee, government, security, utilities, to coordinate to address that particular issue. What the standard will address is, now that you have deployed the ABM, what should the public expect in relation to the performance of that ABM? And it's still going to be on even if it's by region, it's still going to be fairly, we can't legislate how every single ABM operates across the island. It just becomes burdensome. So I do take the points. They're well noted, and I think it is to understand what a standard can accomplish. A standard can accomplish change in behavior in relation to what is installed. But there is going to need to be different types of policies to actually change that. We are at 884. Perhaps Jamaica needs 1,200 ABMs. And maybe those 1,200 ABMs need to be dispersed more evenly across the island. And those are broader policy questions that have to be looked at and can't necessarily all be resolved through a standard of sound practice or a regulation. What I can say is when we look at the data, we do see that there is a high concentration of ABMs in urban spaces vis-a-vis rural spaces. So we know this. The last thing I will say is when we had polled the licensees, banks, this was 2 months ago, they do intend to continue to invest in ABMs. I believe the projection over the next 2.5 years was would peak at $500 million per year, at least over the next 2 years. So they are planned investments, but the issue is really in terms of ensuring that the deployment is fit for purpose. Thank you.
Mr. Chairman. Mr. Chairman.
The question that I had on non-cash branches, because it's something that has become a thing. You didn't address that one. So is it a policy of BOJ, or do you allow banks to just internally decide whether this branch be a non-cash branch and whether they actually remove their footprint? That is a section of the question.
Yeah, so at this point, the banks make an assessment in relation to the business model that they're using in a particular location. However, having a banking license means that you should be providing the facility. So it really will boil down to ensuring that for a particular business model is consistent with their obligations to what? Receive cash and to pay out cash as one of their obligations, right? So providing for deposit taking is why you have a deposit taking license. And that's one of the things that we would look at. Part of what we also observe, even as banks are transitioning, some of them are using non-cash branches. They do provide in-branch ABMs, and that's something that we look for carefully. That if they are moving to not have teller-based cash services, that they do facilitate ABMs that allow for transactions in cash. So that's something that we look for when those applications do come forward.
Member Hilton, you have the last question on the floor now.
Thank you, Chairman. And I want to, I'm an urban member of Parliament, but I do feel the pain of the rural MPs in this matter. And I believe it raises some profound policy question. And my only difference, I differ with the bank and the Bank of Jamaica, in that I really believe the Bank of Jamaica, as the regulator, has to be enjoined in this search for solution in a more direct way. It's not simply the Minister of Finance and the banks and whichever other ministry. The Bank of Jamaica has to be as engaged in this search for a solution, because the impact on the economic performance is being affected, and not least the welfare of the population as a whole. So I don't think it's an hands-off approach. The bank cannot take a hands-off approach on this matter and simply saying, well, we set some standard and we just have to look to see how it operates. I think as in any standard and as in any new initiative, there has to be the mechanism for review and to see how it operates and to make changes where it's possible. But I do agree that a broader conversation has to take place and continue, because what is happening to people in their quality of life and in the performance of the economy is at stake and is being affected. And I think it is urgent and impatient of some quick action. Let me conclude by asking this question, though, because I think part of the solution is a matter that I want to address, and that is competition. Let me, Governor, are you satisfied with the level of competition in the banking sector? And if not, when is the issue, for example, the specific issue of portability of account might be addressed as one possible solution to improving the competition within the sector?
I think I can say very clearly we are not satisfied with the level of competition. And it's particularly clear to us in this period of high inflation. And we are working to address one of the issues that causes lack of competition, and that issue is the difficulty in moving your account from one institution to another. And in particular, the hoops and hurdles you have to jump over to open an account, all of the criteria you have to meet, and the documentation you have to present. And up to this morning, we had discussions with members, with the government, really, continued discussions with the government, briefing them as well as the banks on the project that we have to make the documentation that's required to open an account, make it electronic or digital, and make it centralized so that it can be available at an instant when the customer desires it to open an account or to move their business. So that is a project we are actively working on and consulting with both the government, in particular the Minister in charge of technology in government, as well as the Minister of Finance, as well as the banking sector, all of whom we have had meetings with up to this morning on that particular project. We expect that that project will take us between 18 months and 2 years to be completed. It has a number of technology things we have to get right. So conceptually, we have to get it right from the beginning. And it does carry with it concerns about privacy, which the public would have in the back of their minds. If I have all of my data and it's in a central depository, is it private? Is it going to be raided with some cyber attack? Will government know my business? All of those concerns that existed with NIDS, for example, would to some extent exist. So we're cautious about it, but we want to give it a try and make it work. We have instances of jurisdictions that have implemented it, and it's like night and day between what used to exist in trying to open a bank account, 2-3 days of work to get it done, to what it is currently with the centralized digital system, which means it takes minutes to open a new bank account. So once we can overcome the hurdles of technology as well as privacy, and we can instill confidence in the banking public, in the customers, that this information will be held securely, I think we'll be well on our way to addressing one of the major impediments to greater banking competition. So people can feel that if I'm not getting a good interest rate here, let me move my account. It won't involve me spending the next 2 weeks getting documentation to do it. It will take me a couple of minutes to get it done. If I don't like the service, if they don't have enough ATMs, whatever is the reason, I can move my account pretty quickly. So that's a big project that we have.
Thank you, Governor. I just wish you well and wish you Godspeed in getting this done, because the country needs it and the population does as well. Thank you.
Just wanted to say in closing, Chairman and members, that we at the BOJ want to play a more proactive role in this issue of the distribution of ATMs, because it is an issue that the public feels very aggrieved by. But all I'm saying is that the best place to start it is right here, because you know the nooks and crannies of the geography that you are responsible for. And you can say, well, an ATM here and an ATM there would greatly relieve the congestion that we're having. When that is kind of put together with all of the various constituencies, we then get a picture of what is desired, from which we can come up with a picture of what is possible, because not everything we desire is going to be possible. There is a cost involved, and there's going to be time to get that equipment in. But I think the right place to start is here, and we would be very happy to play an active role in trying to coordinate that with the Minister of Finance, and it has to be him, because there is going to be a cost that government needs to step in and stand behind.
Thank you, Governor and your team. We have no further question for you, and so we want to thank you for coming and for making your presentation and for answering all our questions. We wish you well, and we are hoping that because of us having this meeting, we'll see some further improvement. Thank you. Yes. So we are now on to any other business. There being no other business, the date for our next meeting, we are proposing that the date be Tuesday, September 24th. And Tuesday, September 24th, we will have the PIOJ to come and give us a report. Okay, but this is subject to the PAC needing that date, because we are cognizant of the convention for Tuesday morning. But we understand there are some other variables, and so we are proposing the 24th of September, 10, tentatively, subject to any priority that may be given. With that said, this meeting now stands adjourned. If we have somebody moving, we have Member Lawrence moving and Member Wilson seconding. Meeting now stands adjourned.